Sir, I rise to speak on the Company Law Amendment Act 2016. I did not want this debate to be a bipartisan debate or a partisan debate. I wanted this to be a general discussion on the problem of companies, because very often in recent times problems regarding companies have come up. We had the collapse of the Shottam computers. We had the history of the Ponzi companies. And recent times what we are hearing very much is about the shell companies that have been floated post demonetization. Our Honorable Kirit Somaiya brought up many issues including about elder pharmaceuticals. My request to him would be to directly go to the minister. In the Corporate Affairs Department, he's got the SFIO, Serious Fraud Investigation Office. If somebody has done wrong, let the government take action through the SFIO. Instead of raising it in Parliament, for us opposition people will raise it in Parliament. For people belonging to ruling party, they can always approach the minister, talk in the party meeting. I don't know why Mr. Somaiya, Honorable Mr. Somaiya, decided to go take that route. Secondly, he mentioned about demonetization. He says that demonetization has been proved to be correct because of UP elections. This is strange to relate one thing to the another. They will say that everything, cow lynching is also supported by UP. Gorakshak lynching by Gorakshak is also related to victory in UP election. These are entire different issues. The bad effects of demonetization are being felt now. In the first quarter of 2017, already the GDP has gone down by 1%. Small industries have been destroyed altogether. And we have been trying to repeatedly find out how much money has been deposited in the bank after demonetization. Till today, the Reserve Bank governor has not been able to say how much money was deposited in the banks after demonetization. So I do not want to go into those matters. As I said earlier, this should not be a partisan debate, because companies law, which was passed during UPA 2 regime 2013, that was the result of a long discussion. The bill was introduced in 2011, then it went to standing committee, then 2013. At that time, Veerappa Moily was the minister, then Sachin Pilot became the minister. He piloted the bill through in 2013. Now that bill brought a whiff of fresh air, because the old company law 1956 was outdated and was not competent to deal with a liberalized economy. So the 2013 Act was very much appreciated by business circles. Now when the NDA came to power in 2014, obviously it was a new government, they wanted to do something. So many people represented to them about problems being faced in the implementation of the 2013 Companies Law. Now, out of the 470 sections of the Companies Act 2014-13, 284 sections were already implemented, and the National Company Law Tribunal has now been set up. So there is no problem, but still when these people, businessmen, chartered accountant, went to the Finance Minister, Mr. Jaitley, he first brought in an amendment in 2015. Now that amendment was discussed in the Rajya Sabha. Rajya Sabha gave certain suggestions regarding the 2015 amendment. At that time, government set up a committee called the Company Law Committee, with chartered accountants, cost accountants, company secretaries and a former High Court judge under the chairmanship of Secretary Ministry of Corporate Affairs. That committee submitted a report to the government. Then the government introduced the bill, the current bill, in 2016. Sir, it came to the Standing Committee on 12th April 2016. I am a member of the Standing Committee, so we deliberated on the new bill. And we met all FICCI, CII, ASSOCHAM, we met the Chartered Accountants, Cost Accountants, Bombay Chamber of Commerce, and then the Standing Committee gave a report under chairmanship of Veerappa Moily. It is in line with that report that the present bill has been brought in. So I cannot really object to the structure of the present bill. Only thing I am happy about, and I want to thank Mr. Jaitley, that today he has left it to Arjun Ram Meghwal to pilot the bill. He himself is absent. Mr. Meghwal was a very vocal member of Parliament, but after having become a Minister of State, he does not get so much time to speak. So today he will be piloting the bill and maybe even again replying to our queries, etc., etc. So I welcome him in this role as a Minister of State. Sir, what are the specialities of this new company law? The main object is to improve the ease of doing business, so that people who want to start a business, even a one-man company, a startup, he does not have to go through so much formalities, so many disclosures, so many filling up of forms. So the idea is that make the law simple so that only lawyers do not benefit, the companies also benefit. And that's why this law has been brought. Now, the amendments proposed are expected to simplify disclosure and compliance requirements for companies. Example is doing away with requirement of government approval for managerial remuneration and replacing it with approval to a special resolution by shareholders in general meeting. It's a good addition. The bill has also suggested simplifying the format of the board's report and recommended avoidance of repetitive information. Requirement of filing an extract of annual return as part of the board's report has been removed. An exemption has been provided for uploading individual financial statements of stepped-down foreign subsidiaries by listed holding company, where consolidated financial statements have been prepared by foreign subsidiaries in according to the laws of the relevant foreign country. In the interest of transparency and fairness, guiding principles for determination of penalties have been introduced, such as size of company, nature of business, injury of public interest, etc., etc. To encourage startup, the amendment bill proposes several incentives to startups and small companies. Precondition for a company to be considered small have been relaxed, and so has the format of board's report and annual return for one-person companies or small companies. The fine for non-filing statutory annual filings have been significantly reduced. They have been provided more avenues to raise funds. This is also a good thing for startups. Now, one problem is of harmonizing laws. There is the Companies Act and there is also the SEBI Act, the Security and Exchange Bureau of India Act. They overlap. Now, an effort has been made to remove that. The resultant ambiguities often overlap, dissuade companies for complying with relevant laws. The amendments are geared towards doing away with dual requirements, especially in the context of separate prescriptions for prospectus and the contents of the board report. Prohibition on forward dealing and insider trading have been omitted, since those are relevant for listed entities and already regulated by CBI. Those companies which are listed, they are regulated by SEBI. So there is no need for keeping them in the Companies Act. Also, unlisted companies will now be allowed to convene annual general meetings at any place in India, not at their registered office necessarily. The bill has empowered the centre to exempt any class of foreign companies from applicability of registration and other requirements provided in the Act. I do not know if this is an unmixed blessing. I have a slight antipathy towards foreign companies because they often put in money and take it out. We have no control over that. But the bill attempts to address provisions that were criticized on the grounds of being onerous, relaxing the restriction on number of layers of subsidiaries as a much needed step towards giving companies greater freedom in the way they structure themselves. So this amendment bill will remove many ambiguities from the current law and streamline its provisions with other relevant laws. So only thing I want to mention here is that there are certain, I earlier mentioned the Company Law Committee which was set up by the government. Now, certain recommendations of the Company Law Committee have not been incorporated in the bill. These include issues related to 1, resident requirement for directors, and 2, compliance requirement for dormant companies. Sir, also now the new restriction will prevent a company from attracting a talented individual residing outside India. The CLC recommended that this residence requirement for a foreign national should be removed, but that has not been done. Also, the new suggestion was under 2013 Act, any company without transactions for previous 2 years may apply to obtain the status of a dormant company. The 2013 Act does not exempt such dormant companies from requirement to constitute committees. The Company Law Committee suggested that dormant companies may be exempted from constituting an audit committee as they have no business activities or employees. So lastly, I want to say that the Supreme Court upheld the constitutional validity of the National Company Laws Tribunal. However, the court held certain provisions in relation to the qualification of technical members of the NCLT. Composition of the selection committee for appointment of technical members of the NCLT, that is National Company Law Tribunal and National Company Law Appellate Tribunal, as invalid. This bill has modified this provision to bring it in line with the Supreme Court decision, which is a good thing. Sir, to end, we want good corporate governance in India, because as the economy expands and is liberalized, it is necessary to have proper regulation as well as allow companies the freedom to grow, freedom to invest, freedom to attract investment. This bill, the intention is to improve the ease of doing business. We shall have to pass the bill and then see what response we get from the corporate world. I hope that Mr. Arjuna Meghawal, as looking after the corporate affairs department, will use the powers of the department to really save people. So many people have sunk their money in companies which did not pay their depositors. Companies have raised monies in so many fraudulent ways. The need of the hour is to see that the common citizen of India is free of all these encumbrances. With this, sir, I end my speech on the bill. Thank you.